Morning, everybody. I trust that you're all staying safe and well. So essentially, we're dealing with a scenario at the moment where we have a lot of employees who are unable to work and are not being remunerated. And because they're not being remunerated, there are no contributions being paid on their behalf to funds. We're also dealing with a scenario where employers are needing to cut costs, and one of the cost-cutting mechanisms they're looking at is the reduction in contributions and using the rules that have been spoken about to reduce contributions. Now, you're all aware that your admin costs are usually recovered from your contributions, as are your expenses, and now you're faced with a scenario where you're not getting the contributions and you can't make the deductions from them. So the issue is, and as I understand it, there are a number of rules where permission is granted to allow you to go into, for instance, a members fund credit in order to recover those expenses, and an issue's arisen as to the lawfulness of that. I've looked at the Act and tried to understand where the arguments could be that there could be any unlawfulness to it. So the first obvious issue is, if you dip into somebody's fund credit, where would you then have sufficient money to pay their minimum individual reserve when they have to withdraw from the fund? And that obviously takes you then to the very fancy definition of what is a member's individual reserve. And we all know that in a defined contribution context, it's your your member's individual account together with a share of the reserves. Now, if you go to the formula, and you all know this formula backwards, for the members fund credit, it's obviously MC plus EC minus X plus IC plus OC, and you all know what that means. So you've got to ask yourself whether you are going to be within MC plus EC minus X plus IC plus OC. So just to slow it down, what it is that your fund account is your member contributions plus your employer contributions minus expenses plus investment return, and then OC is any other amount that may lawfully be permitted, credited to, or debited from the member's individual account. So there is a specific contemplation in calculating the individual account where the rules permit it to debit an account with, for instance, a funds expense. So I don't see that it in any way would infringe your ability to pay the minimum individual reserve. So I don't think we've got a problem there at all. The next issue then was whether it in any way infringed Section 37 capital A. Now, you all know that Section 37 capital A says that you may not reduce, cede, pledge, deduct from a member's benefit. And the issue is whether if you are deducting an expense from their fund credit, you are in any way deducting from their benefit. Now, again, I don't think it infringes 37A in any possible way, because the benefit that you may not reduce is the benefit determined in accordance with the rules. And the benefit determined in accordance with the rules already has the expenses deducted. And we all know that there's a whole number of typical deductions from a member's fund credits, for instance, your investment costs and stuff like that. So clearly that wasn't contemplated. I'm also aware of an argument that says the only permissible deductions in terms of a fund's rules are in terms of 37 capital D. Now, you all know what 37D is all about. 37D says that there are specific things that you can deduct from a member's benefit. And for instance, it's a housing loan default, money stolen from an employer, divorce, maintenance, those kind of issues. And there is a specific provision in 37 capital D that says you may deduct from a member's benefit contributions to a medical aid and contributions to an insurance policy. And an argument was put forward to say that because the only deductions are for medical aid and insurance policies or benefits, there can be no deduction of expenses. Now, I don't believe that that's correct at all. It's quite a technical legal analysis, but I think that the benefit being referred to is the ultimate withdrawal benefit. It is not the fund credit and what you've got as an individual reserve at that point in time. So I don't think it's covered by the wording, and I think that that argument is absolutely wrong. And if it was right, it would then prevent a whole lot of other stuff being deducted as well. So insofar as there's any resistance to registering a rule that allows you to take expenses from a member's fund reserve, I don't believe that that would be warranted at all. And I think you're entitled to have those rules, and I think that they're enforceable. Turning then to the risk-benefit premiums, again, you've got to go back to your old favorite formula of MC plus IC plus dollar X minus IC, et cetera, and ask yourself whether it's one of those things. Now, again, if you come back to that definition of OC, you may lawfully debit a member's account with anything that the rules permit you to do so. So if you're permitted to do so in terms of your rules, you would be entitled to take that any insurance premium and pay that over to the insurer on behalf of, and it wouldn't infringe that. It's not an infringement, again, of 37A. And insofar as there's any argument about 37B, well, then that specifically contemplates the payment of an insurance premium. So I think with both fund expenses and insurance costs, if your rules permit it and you've got lawfully registered rules, I think you'd be completely within your rights to take from the fund credits in order to pay those two things. And I mean, we all know right now the importance of retaining insured benefits. This is not a time when you want members to start losing insured benefits. So we've got to do whatever possibly we can do to make sure that insured benefits are retained during this very, very critical period. You don't want people dying on you and finding that those disability benefits or death benefits are no longer available to you. Now, I was asked whether the same could apply in the event that it's an employer-owned policy. Now, I'm aware of many fund rules that have a definition of contribution that deducts whatever the employer-owned policy contribution is from that contribution. And I know that it's often the practice of funds to collect that contribution from the employer and pay that contribution over to the employer, even though it's the employer's policy. In this sense, the fund merely acts as a conduit to pay that, to collect that premium and pay it over to the insurer. It's an employer-owned policy. It never becomes an asset of the fund. It is completely separate from the fund's assets. So I don't see in any way that it at any point in time belongs to the fund. Similarly, there's no legal obligation on the fund to make that premium payment on behalf of the employer if the employer defaults. And I think it would be unlawful to dip into the fund's accounts, credits, anything, in order to pay that money over on behalf of the employer. You simply can't use fund money to pay an employer obligation, and that would not be permitted in any way as I see it. So I don't think for your unapproved insurance policies that you'll be able to make those payments on behalf of an employer. Leanne, I hope that answers the questions that you asked of me.
Thank you so much, Graham. It certainly answers my question, and it's answered a lot of questions for people who sent questions to us beforehand as well as during the video as well. So thank you very much for that. Do any of the other panelists have anything that they would like to add on that question?
Yeah, I can.
Okay, thanks, Carla.
So an interesting topic that's come up in numerous questions that we've seen even prior to the panel has been around funeral benefits. I think given the nature of the pandemic as well and the importance of the funeral benefits to lots of fund members, it seems to be in the forefront of the minds of many trustees and principal officers. And I think the answer with regards to that and whether it can be deducted from members' fund credits it follows the exact same reasoning that Graham's just set out. Your first assessment is whether it is a fund benefit or whether it is in terms of an external employer policy. That's the first step to always assess. As Graham indicated, there is a different legal position that your fund benefit, if it is a fund benefit, then it can be deducted. If it's an external benefit, then it can't. And that depends on how it's been structured. And this has always been a very contentious issue. And it goes back to an exemption that applies with regards to the friendly societies, pension funds being able to perform the objects of a friendly society, provided that they stay within those limits, funeral benefits forming part of those objectives. So there's a very complex legal discussion that we won't unpack now that provides that up to a certain limit, some funds can, well not some funds, all funds can provide funeral benefits legally up to a certain criteria. And those could then be even self-insured fund benefits. And if that is the nature, that they are a fund benefit, then Graham's reasoning about it, the contribution being deductible applies. But if it is in terms of an external fund or employer-owned policy, where the fund is just acting as the conduit, then again, Graham's reason would apply that would not be possible to deduct that from a member's fund credit.